We are going to just wait for another few minutes as people are joining the webinar. For those of you who have joined in the last few minutes, I did want to let you know that this is a webinar, not a regular Zoom call. So it's perfectly normal that you can only see the presenters and not the other participants. That's just a function of this being a webinar. I'm going to wait just a few more seconds and see if anyone else is still joining, and then I'll be kicking things off. Okay, I see that it's 7:03 and that the numbers aren't going up a whole lot. So I'm going to go ahead and kick this off. My name's David Young. I'm a member of Brentwood United Methodist Church and a volunteer with NOAA's Criminal Justice Task Force. NOAA stands for Nashville Organized for Action and Hope. And our mission is to combat systemic injustices through community engagement, training, and direct public action. The mission of the Criminal Justice Task Force is to organize and take actions for a more humane, safe, equitable, responsive, and restorative system of justice in Nashville. One of the biggest hurdles that people have when the judicial and DA elections come up is that they don't know the candidates. So this forum is our chance to hear from the candidates and to ask pointed questions about the issues that concern us deeply. Even more importantly, this is a chance to get their commitment to work with us on the critical issues that you've heard about tonight. To create change, we have to be in relationships of accountability with our elected officials. This is the first of 5 forums, all of which will be webinars on Zoom. This one is for the Criminal Court Division 4. On April 3rd at 3 p.m., we have the Criminal Court candidates for Divisions 3 and 5. On April 5th at 7, we have the candidates for the General Sessions Court Divisions 5 and 6. Then on April 7th at 7, we have the General Sessions candidates for Divisions 2, 7, and 8. The forum for the DA candidates is on March 27th, this Sunday at 3 p.m. I'd like to welcome and thank our moderator and our candidates for their participation. We have Joy Kimbrough as the moderator. The candidates tonight are Cynthia Chappell, Seth Norman, Tillman Payne, and Marcus Shute. The schedule for tonight's going to be controlled by our moderator. We're going to start with 2-minute introductions by each candidate, and then the moderator will pose the first question. Each candidate will have 2 minutes to respond. We do have a timekeeper that will give a single warning when a candidate has 30 seconds left to speak. We'll get through as many questions as we can. And after about 30 minutes, we'll start asking questions that come from the audience. Please post those in the chat, and then we'll go through those and direct those to the candidates. If your question is directed to a specific candidate, please indicate that. If we still have time, we'll then go back to our prepared questions after the audience questions are complete. Finally, after the last question, each candidate will be given 1 minute to make a closing statement. So with that, I'm going to turn it over to our moderator, Joy Kimbrough. Thank you.
Thank you. And I believe we're supposed to start with the introduction of the candidates. And so if each of you would introduce yourself, we'll start with Ms. Chappell.
Yes, thank you, Noah, for organizing this event. I am Cindy Chappell, and I'm asking you to choose Chappell for Criminal Court Division 6. A little bit about me personally. I am the daughter of retired public school teachers. I'm a mother of a senior at Hume Fogg and a 7th grader at Meigs. I graduated from public school myself in 1986. I went straight to college at Rhodes College in Memphis and got my degree in psychology. Although I thought I might go into the FBI or the Secret Service at that point, I was fortunate enough to have a scholarship to Memphis State Law School. And so I went to school, and I'm so grateful that I did go to law school because I have loved my practice for the last 29 years. I have practiced primarily criminal defense, representing individuals and occasional business, but 95% individuals. I've represented and fought for people accused of crimes, but I've also represented victims of crime. I believe I'm qualified for this position. I am running for this position because of my experience, my qualifications, which include practice at every level of a criminal proceeding, from motion practice to trial. My undergraduate degree in psychology has been very beneficial to me in the last 29 years because I understand both personal ills and societal ills that impact crime and criminal behavior. Mental illness, substance abuse, poverty, lack of education, bias, lack of family support. All of those issues are important to understand and their impact on our criminal justice system. I'd ask you to look at my website, cindychappell.com. I have many people that are standing in support of me, both that have worked alongside me and have observed me in the courtroom. So I'm asking you to choose Chappell on May 3rd. Thank you.
Thank you. All right, Mr. Norman.
Yes, thank you again. My name is Seth Norman, and I want to be your next judge for Criminal Court Division 6. I'm asking for your vote in this primary election on May 3rd. So let me tell you just a little bit about myself. My wife, Andrea, and I have two wonderful twin girls, and I want Nashville to be a safe place to raise them, to live, and to work. I'm a fifth-generation Nashville native. I graduated from Hume-Fogg Magnet School in downtown Nashville. I am someone who's driven to learn and to accomplish their goals. I went to Western Kentucky University, where I graduated in 3 years, while also being active in both the Student Government Association, where I served as a senator, and as the director of public relations. I was also active in Phi Sigma Pi National Honor Fraternity. Upon returning home to Nashville, I got a job with the Criminal Court Clerk's Office, where I continued to work full-time through law school. While in law school, I served on the Honor Council for 2 years and served as the president of the Honor Council for 1 year. While working in the clerk's office, I was an in-court clerk for Judge Dalton for 3 years. And after graduating and immediately passing the Tennessee bar exam, I was a law clerk for Judge Thomas Brothers for 2 additional years. I'm a fourth-generation attorney, following the footsteps of my father, Jay Norman, my grandfather, Seth Norman, my great-uncles, Jack Norman Jr. and John C. Toon, and also my great-grandfather, Jack Norman Sr. And I'm proud to continue my family's tradition of practicing law here in Nashville. Since starting my own practice, I've represented over 1,000 people in criminal proceedings in Davidson County alone. I believe that every case is unique. And too many attorneys have the mindset of, I've seen one case, so I've seen them all. This is unacceptable. And that's not how I will act. If elected, I will be fair. I will constantly and carefully listen and consider all facts before making decisions. I'll remain open-minded while staying grounded in reason. I will treat everyone with respect, regardless of their age, gender, race, socioeconomic status, or affiliations. I'll follow the law. This will include continuing to learn and evolve with the changing law. And I'll seek justice.
Okay, thank you, Mr. Norman. Next, Mr. Payne.
Hi, my name is Tillman Payne. I am running for Criminal Court Division 6. I am a retired Air Force officer. A little bit more about myself. I grew up on a farm in Middle Tennessee, Carthage, Tennessee. Both of my parents were school teachers. My dad taught vocational agriculture, and my mother taught elementary school in Trousdale County, and my father taught at Gordonsville in Smith County. Following high school, I went to the University of Tennessee in Knoxville. I was on an ROTC scholarship, and I was commissioned as second lieutenant after graduating. I graduated with a degree in vocational agricultural education. And following that, I went into the military. I spent 20 years serving our country. Most of that time, I was a logistics plans officer, basically handling supply, transportation, and maintenance, moving men and equipment all around the world for various jobs. I spent time overseas. I lived in Spain for 3 years. I lived in Korea for 2. I was a member of the Checkmate team at the Pentagon, a what if planning team. I was a logistician on that team. I also was an executive officer for 2 general officers, one at the U.S. Air Force staff level, the other at the Defense Logistics Agency in Virginia. I also was a commander, a detachment commander for a detachment out in Korea, managing war reserve material. Now, nothing that has that to do with being a judge, but when I got ready to retire, I realized that I was going to be really too young to retire. So I really thought, what do I really want to do now? I decided that the best thing to do was to try to help people. And to help people, I thought being a lawyer was the best thing to do. So therefore, I became a lawyer. I went to law school, graduated from George Mason University School of Law in Arlington, Virginia. Since that time, I was assistant public defender for 5.5 years. Handled thousands of cases. I've tried everything from traffic citation to first-degree murder trials, and won at every level. I'm asking for your vote on May 3rd, but don't wait till May 3rd. Let's vote early, and let's go April 13th through the 28th and get this done. Thank you.
Okay, thank you, Mr. Payne. And now Mr. Shute.
Thank you, Joy and Noah, for this opportunity. My name is Marcus Chute Jr. I'm running for Division 6 Criminal Court Judge. I'm a Nashville native. I attended Meigs Magnet, Hume Fogg, Tennessee State, and Nashville School of Law. I live in the Talbot's Corner area with my wife, Natalie, our 2 daughters, and our chocolate lab, Grizz. I believe that Nashville is ready for fresh ideas and a new perspective on how we handle things in our criminal courts. Some of the things that we have been doing have not been working. And with Judge Fishburne retiring, it gives us an opportunity to continue the standard that he set for a fair courtroom. It's my belief that a courtroom should be where every participant of the legal system, from the victims, defendants, criminal defense attorneys, district attorneys, police officers, should first be treated with respect and dignity. And then they should know that their testimony will be listened to fairly and the rule of law will be applied equally. I believe that a judge should have courage and integrity. And for me, that means the courage to do what the law requires me to do, even if the course I must take is not a popular one. And also having the integrity to not to allow myself to be influenced by one's race, gender, sexual orientation, or wealth or lack thereof when they come in my courtroom. I founded my law firm, Shute Law, after facing my own legal discrimination when trying to enter the legal professional field. And I founded it with the purpose to help the community and serve those that are often overlooked and unheard. I've represented indigent clients with small cases from misdemeanors, DUIs, and simple possession, to homicide, first-degree murder, and felony drug cases. A lot of those cases I've taken to trial and argued to verdict. I believe I have the experience and judicial temperament to be patient, kind, respectful, open-minded, yet understanding, and firm, and then just using my common sense when making decisions.
30 seconds.
I believe that restorative justice is an important component to heal our communities and bringing our community together. So we need to look for alternative sentences rather than just incarceration and locking people up. You can find out more about my campaign at chuteforjudge.com. And remember to root for Shute. Thank you again for the opportunity.
All right, well, thank you, candidates. I will begin reading these questions that were submitted to me by the sponsors. These are not my questions. I will only read them. Some questions will have multiple subparts, but they will be asked as one question. And please respond to all of the subparts. All right, and I'll start with Ms. Chappell. She'll take it first, and I will go forward with Mr. Norman, Mr. Payne, and Mr. Shute, and then we will begin rotating. So whoever goes second this time will be first next time, and so forth. Okay, Ms. Chappell, can you hear me?
Yes.
Okay. As a sitting judge, you will dispense justice through your judicial values and lens. What is your judicial philosophy with respect to accountability and punishment on the one hand, and rehabilitation and restoration on the other?
Yes, thank you. Let me tell you about my values in the way my 6-year-old son told me after a unit on law in the legal system. He brought me this crystal and it's got words written on it. I keep this at my desk, and I'll start with this. The first word is love. The second one is peace. The third one is honor, spelled O-N-R. That's one of my favorites. Brave, grateful, and justice. I would say that those words represent my values and what I'm about. And in looking at my philosophy on accountability and punishment, certainly as a sitting judge, there has to be accountability for criminal behavior. There has to be accountability because I have a responsibility to the community to know that I am taking criminal behavior seriously with regard to public safety. Absolutely. However, I also believe that there is a role in the justice system for rehabilitation and restorative justice. As a sitting judge, I've got to apply the facts of every case independently to the constitutional, statutory, and case law that follows with that case. At the same time, when it comes to sentencing and within the bounds of the law, it seems to me that when appropriate, certainly with youthful offenders, certainly with nonviolent offenders, certainly with first-time offenders, we've got to look at alternatives to incarceration.
20 seconds.
Thank you. And I believe I've answered your question and stated my philosophies on those issues. Thank you.
Okay, thank you. Mr. Norman, the same question.
Yes, ma'am. So I believe that we first have to look towards the sentencing guidelines under Tennessee Code Annotated 40-35-103. Those guidelines are very clear when they state that confinement should be necessary to protect society, but they should also only be when actually punishing someone is appropriate and putting them in jail only to the extent necessary. We should not sit there and just incarcerate people for as long as possible just because. We also need to look at all the facts in the case, and we look at all the sentencing guidelines to determine whether or not a rehabilitation treatment program can be effective with that individual. I believe things such as drug court are incredibly important for not only the money that they will save taxpayers, but they will also in turn help to lower recidivism. Drug court, drug treatment, and mental health treatment are incredibly important because it gets people out of the rotation, out of the system, and lets them live productive lives. I'm specifically a supporter of drug court because of my grandfather, who started the drug court here in Davidson County. And I believe that all the people over the years that have approached me and told me their stories about how drug treatment has changed their lives and was able to get them the help that they needed to actually progress forward has molded me to believe in drug courts and drug rehabilitation.
30 seconds.
I believe that as far as respect and punishment, we need to make sure that we're only punishing to the extent that is appropriate, because that is in its very nature the respect to the system as it is. We need to follow the law. We need to make sure that it is equally applied to all people and that no one is overpunished because of any individual characteristics, be it age, race, sex, gender. And I believe that answers the question.
Okay, well, thank you, Mr. Norman. And next, Mr. Payne, same question.
All right, thank you, Joy. Well, let me start with values. My values are very simple. I believe in God. I believe that we need to be fair with people. We need to be honest. We need to have integrity. And we need to be consistent. And we need to try to make this world a better place. So value-wise, I'm looking at always trying to see what can be done to improve a situation. I look at my job as a lawyer to basically apply that to every aspect of a case. I get clients who have committed crimes, and I have to look at making sure that I look at them more as an individual as opposed to the crime that they committed. As a sitting judge, that's exactly what I would do. I would look at the facts, look at the law, look at the issues related to that individual, education, home issues, mental issues, substance abuse issues, all of those issues. when you're a judge, you're basically making decisions based on a set of facts and the law that have to apply to someone's life. I believe that as far as punishment goes, punishment and accountability are sometimes confused to be the same with each other, but they're not. Accountability is once someone has been acknowledged they have been involved in a crime or acknowledged as
30 minutes, 30 seconds.
an issue, then their accountability is there. Punishment comes when you want to deter someone from doing something. Our laws don't need to change one bit. We just need judges that are willing to balance all of those issues to ensure that the punishment is appropriate, that accountability is made so that the public can be confident and feel safe, and that we need to do this in a way that is consistent across the board.
Time.
Thank you.
And thank you, Mr. Payne. Same question, Mr. Shute.
Thank you. So for me, when we look at punishment, accountability, and restoration, for me, the first thing that we look at is, as my role as a judge would not be to push any particular ideology, I would first have to have a neutral position for any case that would come in front of me. And then take a look at the facts as they apply to the particular case and the law that is going to guide how I interpret or apply the facts and to make a determination in that case. I believe that it's imperative that we have accountability in the system. However, I think it's also important to understand the full scope of how the punishment may impact not just the defendant, but the defendant's family. And then also, is there a component that allows the victim to get a sense of restoration, whether that's a victim impact statement or an opportunity to have a conversation with the defendant. I think that it's imperative that we have the restorative justice aspect and ensuring that when one has committed a crime and they have been accountable for what they've done, they get an opportunity to be successful once they've completed their time in jail or they're on probation. Some things that are very important, like mental health court, drug court, veterans court, those three things are things that have highlighted some issues in our community that we recognize and see that need specific attention to how we handle those types of cases. So if I were elected judge, those are the ways that I would implement the balance between punishment and accountability and restorative justice.
Okay, well, thank you. All right, so the next category, that's our lightning round of questions. And so I will read a statement and you will either agree or disagree. If you disagree, you will have 15 seconds to explain why you disagree. And this time we will start with Mr. Norman on the first, and everybody, you will agree or disagree to the exact same statement. So Mr. Norman, criminal court judge campaigns should refuse contributions from the bail bond industry and those who own or are employed by the bail bond industry.
I would disagree. I believe that the bail bond industry, just like all citizens, should be involved in each one of these elections. They have a voice, especially the citizens here in Davidson County should be all heard equally.
Okay, thank you. Mr. Payne?
I would also disagree. The bail bond industry are made up of individuals who are taking care of their families. Also, this industry does provide a service. How it's managed is up to the judicial system. So I would disagree with that.
Okay, thank you. Mr. Shute?
I as well would disagree. I believe that everybody should have a voice and the opportunity to be heard in our election system.
All right, thank you. And Ms. Chappell?
Yes, I disagree. I think individuals, not so much an industry per se, have the ability to participate in judicial elections, and they should.
Okay, thank you. Next statement. Criminal court judges should not require or increase bail for people who violate probation if they have not been charged with a new serious crime. Mr. Payne?
Well, that's a great question. because I would disagree with that, because the way you set that question up, there's no way that you've considered the factors related to bail, whether bail should be increased or not. The statutes are very clear as to what factors should be considered, and those should be considered irregardless of any issue. And so I would disagree with that.
Thank you. Mr. Shute?
I as well would disagree with that. I don't think that, it should automatically increase. I think that we need to take into consideration the bail factors and also some of the socioeconomic circumstances that may have involved the probation violation. So I would disagree with that, just how that question is framed on its face.
Thank you. Ms. Chappell?
I would disagree with how the question is phrased, but I would certainly support efforts to change factors that we are required statutorily to consider in that situation.
Thank you. Mr. Norman?
And I'm going to follow up with that disagreement as well. I believe that Tennessee Code Annotated 4011-118, which is the bond factors, they set forth different factors that we need to look at when making bond decisions, and just a blanket statement of will not change, I could not support.
All right, thank you. Criminal court judges should support court watch programs through which the public can sit in courtrooms to observe how courts function. Mr. Shute?
Yes, I absolutely agree.
Okay. Ms. Chappell?
Agree.
All right. Mr. Norman?
Absolutely agree.
Mr. Payne? Mr. Payne?
I'll make it unanimous. I agree also.
Okay, thank you. All right. Criminal court judges should ensure that everyone charged with a crime who cannot afford to hire an attorney should be able to choose appointed counsel who the judge determines has the time, competence, and resources necessary to provide full and zealous representation. Ms. Chappell? Ms. Chappell?
Thank you. Without knowing more, I would have to disagree with that statement. I would not necessarily oppose changes in the programs that we have now, but absent additional guidelines, I think choice might be something I could not approve without knowing more.
Mr. Norman?
I believe in the constitutional right to an attorney if you're being charged with any crime, so I would agree.
Okay. Mr. Payne?
I think that the choice issue is a problem for me. So I would have to disagree with allowing the choice issue, because that might get into a series of several different choices. I think that if the judge knows a competent attorney, has the capabilities, and they appoint that person only under some extreme circumstances to change that requirement. So I would disagree.
And Mr. Shute?
I would agree because I think that when
you said you agree?
Yes.
Okay, I think that's where it ends, Mr. Shute.
Okay.
Okay. All right. Criminal courts should ensure transparency and accountability to the public by providing open access to detailed data about judicial decisions and case outcomes. Mr. Norman?
Well, I disagree, in part agree in the spirit of it. So I disagree with all data purely because there are many cases that are very sensitive nature, child rape, rape. There's so many different types of cases that I can't just blanketly agree with that statement.
Mr. Payne?
I can't blanketly agree either. I think that there are some limitations on some things because of the sensitivity and privacy issues related to children, et cetera. So as a blanket statement, no, I disagree.
Mr. Shute?
I would only disagree just specifically because I don't know what type of detailed data. If we're just talking about disposition of cases and sentencing, then yes. As it relates to any type of exhibits or discovery materials, then no.
Okay, Ms. Chappell?
Yes, I would disagree without knowing what in addition is being sought other than what is already available to the public through Administrative Office of Courts and our clerk's offices. Thank you.
Thank you. Criminal court judges should waive fines and court costs when an indigent convicted person is seeking restoration of voting rights. Mr. Payne?
Let me say that every decision, so I disagree, every decision as it relates to waiving fines and court costs should be considered. But if someone is indigent, I don't think that's basically the reason. There should be other reasons also, so I would have to disagree.
Thank you, Mr. Shute.
As the question is framed and written, then yes, I would agree with it.
Okay, thank you. Ms. Chappell?
I disagree. While I don't like the impact on a constitutional right to vote, I think that's a decision that has to be looked at on a case-by-case basis, not an every situation basis.
All right, Mr. Norman?
As it relates to people who are declared indigent as the question, I would agree.
Thank you. All right. We believe that 8 years is too long a term with periodic public engagement. Will you agree to participate in an annual forum with NOAA and its community partners to review issues related to criminal justice and discuss the progress you have made to address your campaign concerns and promises? Mr. Shute?
Yes, I would.
Ms. Chappell?
I would agree to meet with NOAA. I assume that means I've got to agree to meet with every other group, which wouldn't give me a lot of time to be on the bench, but I'm certainly agreeing to be accountable more than on an 8-year basis.
Okay. Was that agree or disagree?
I agree to meet with NOAA to the extent it does not impact my ability to carry on the work required on the bench.
Oh, Mr. Norman?
I would agree with Ms. Chappell's statement there, as long as it does not impact my judgeship.
Okay, and Mr. Payne?
I would agree to meet with NOAA. I think NOAA has established itself as an important part of this community discussion.
Okay. Thank you all. And that ends the lightning round. And now we'll go back to questions for each of you to answer. Remember, I did not write these questions, okay? Now this one's going to be pretty long. There is a public perception that the current bail system and pretrial detention is unfair and primarily burdens people in financial need and people of color, and is often excessive. Do you agree with this assessment? If so, what, if anything, can you as a criminal court judge do about it? What is your position on bail reform? What factors should judges take into account when making a decision about a defendant's pretrial status? Ms. Chappell?
Thank you. Is that a 2-minute response?
Yeah, unfortunately.
Yes.
I wanted to just make sure I do the right thing. So yes, after practicing criminal defense for 29 years, I think it's more than just a perception that bail, cash bail, certainly, and some forms of pretrial detention are unfairly impact certain groups and individuals. As a criminal court judge, I would be bound to follow the statutory law with regard to that. I would support certainly efforts at bail reform legislatively. I do not believe that people should be in custody, certainly pretrial, simply because they are poor or simply because they are not from this community or for certain other factors. The factors that we have to consider are enumerated in the statutes, 4011, 150, and others that tell us what we've got to consider. There is some amount of discretion in granting bail in cases that qualify for bail, weighing those factors plus taking into account what is the least restrictive alternative to ensure that this person shows up for court and to ensure public safety. Did I answer all of them?
I don't know.
Okay.
I'm trying to keep up with the names.
I did the best I could.
Okay.
Thank you.
Okay, thank you. Mr. Norman?
So as far as the public perception, I believe that that most of the reasons behind the public perception is because they're, by and large, the public does not see what goes on in the courts and they do not understand what factors we're called to address. Tennessee Code Annotated 4011 118 sets the bond factors. And those are things such as length of residency in the community, employment status, employment history, financial conditions, family ties and relationships, the defendant's reputation, character, mental condition, defendant's prior criminal record, the prior FTAs, failure to appears, responsible members of the community who will come in and actually stand up and say, I know this person, I will vouch for him. The nature of the offense, the likely improbability of conviction, the likelihood of sentence, factors indicating the defendant's ties to the community, and the factors bearing on the risk of the willful failure to appear. Now, Nashville has grown significantly in the last decade. And a lot of those factors where you have people moving in who have no significant ties, who don't have people who can vouch for them, and the public sees these high bonds when it's really a determination that the judicial system is making that the risk is higher. I do not believe that bonds should be set any higher than what is actually necessary to ensure the defendant is going to come back to court. And I do believe that each court has to look at the factors involved to make that decision. Bail reform, therefore, I don't believe there should be really a bail reform. I feel like there should be a adherence to the factors as written. And what, if anything, can you do? I would recommend getting in touch with the legislature if you feel that there needs to be change, because that is who makes those changes.
Okay, thank you, Mr. Payne.
All right. First of all, this perception is a reality. It's not just a perception. The current bail system, as it operates, it unfairly treats minorities, people who aren't from the community, et cetera. So therefore, yeah, it needs to be reformed. The question is, how do you reform it? I think there's a lot of effort going on right now in our community with pretrial release to ensure people who have misdemeanors aren't staying in jail for long periods of time. They're trying to get those folks out. I think that we need to continue that effort. As a judge, what I would do is that if people come before me and they're constantly, not constantly, but they continue to be incarcerated, I would review the bail. I mean, is it a real reason this person's not going to be coming back to court? The first thing that we need to think about is not what the bail should be. The question is, should there be a bail at all? The first statute that you address is should the person just be released on their own recognizance? And that's where we should start. If we implemented our procedures the way they're actually written into the statute, we would first determine if there's any reason for bail. If somebody lives in this community, their entire family's in this community, there may not be a requirement for bail. The only time that I think that you got to be careful about that, because we want them to come back to court, is that if there's an issue related to protection of the community. Bails need only be set to get people to come back to court. There's not a perception, it's a reality. I support bail reform. The factors I would consider are the same ones that are in the statute. I don't need to change them. You just need to have
30 seconds.
And that's my response.
Okay, thank you, Mr. Shute.
Thank you for that question. So I absolutely agree that I don't think that it's a perception, it's a reality. For a lot of the clients that I've represented, one of the issues that we face are having being able to meet and prepare for the trial because they're in custody. And a lot has been talked about the statutes and when bail applies and what requirements we need to look at. One of the things, the second thing that's on there, it talks about the employment status, the history, and financial condition. Unfortunately, in most cases, a lot of clients are not in a financial position to where they can afford the bail. And so kind of going to the second or the third question about, what should I take into account when making those determinations is also understanding, socioeconomic impacts and within the community. $1,000 for one person may mean a totally different thing to somebody else. Somebody having set a $10,000 bond and have to acquire $1,000, that could disrupt their entire livelihood. And so those are the things that I think that a judge needs to take into consideration when considering these factors in accordance with the law. And so to make sure, and so those are the things that I think that I could do for my position. So I do agree that some of the things that need to be changed are things outside of the confines of what my role would be as a judge. It would be more of a requirement of our legislature to give us more options. But with what we have, I think that we can do things and impact the community for those that are being held in custody at a high bond amount.
All right, thank you. All right, next question. While holding persons convicted of crime accountable for their actions, we are interested in sentencing practices that will help those who have committed crimes learn from their actions and become better citizens. What is your definition of restorative practices? Which restorative practices do you believe are the most impactful? Are you committed to using restorative practices in your courtroom? How would you implement restorative practices in your courtroom? And we'll start with Mr. Norman.
Writing these down, sorry. All right. So as far as holding people accountable, I think we need to look towards the sentencing considerations to determine exactly how to hold people accountable. So some of the things that we need to look at there are, is confinement even necessary? We'll start with that, and we have to look towards, is society at risk? So each situation is going to be a fact-based determination. And that is how all judges should be, in my opinion. You can't have a blanket idea of how sentencing and how restorative justice and how different situations need to be handled in just one single, black letter rule. We need to look at, is confinement actually appropriate? If confinement is appropriate, what other alternative sentencing can we use next to make the confinement more effective? Things like drug court, things like mental health treatment and rehabilitation, all these things, any kind of classes that they can take while in custody to help put them in a situation where when they come out of incarceration, they can be more prepared and ready to go back into the system of society and not turning right back into the system of jail.
30 seconds.
Far too often I see people who are convicted repeatedly for drug offenses, and those drug offenses can be addressed, but they're not being addressed other than simply putting people in jail. And that's not something that I want to see continuing. I want to see there be more utilization of drug courts and other type of alternative sentencing to stop the recidivism. And I'm probably out of time. Yeah.
Mr. Payne.
Thank you for the question. Sentencing, man, that is it. As a judge, that's one of the most important things you're going to be dealing with. first of all, there's some minimum sentences based on what someone may be convicted of. Then there's alternative, whether you put them in jail or you give them some sort of alternative sentencing. First of all, I think that we need to be focusing not so much on the punishment aspect, even though the sentencing will take care of that, is that we need to be focused on what's going to happen to get that person back to society. A judge's job really begins at sentencing, because if you sentence a person to jail, I guess you kind of get rid of them. You don't have to worry about them anymore. But a judge really should be thinking about, how do we get this individual back towards in our society in a productive manner? I was a public defender for 5.5 years. And I'm telling you what it is. It's education, it's vocational opportunities, it's mental health issues, it's substance abuse, and sometimes it's just being socioeconomically poor. If those issues can be addressed, a person can have a chance to get back. And that's why the programs like drug court, veterans court, mental health court are all been successful and have many people who have graduated those programs and changed their lives. As a judge, what I would do is that I believe that education and vocational opportunities are key. When you assess someone for what their capabilities are, what needs to be done for them in the future, you need to be looking at that. Can you get this person the education and vocational opportunity? I would look to some nonprofits, possibly to the unions that are in our city, to find if there's any programs we could implement with them so that they could train some of these individuals, give them opportunities they've never had before in education. Okay, 3 seconds. But first of all, let's talk about education. If a person doesn't have a high school diploma, one of my primary will be get your high school education before you finish my probation. Thank you.
Mr. Shute.
Thank you. Thank you for this opportunity to answer this question. When I think about restorative practices, I think about everyone that's involved in the system. And so, I know that a lot of things are identified or are focused on the offender who commits the crime, but I think it's also important to look at the victim, how the victim can be made whole. When I handled an attempted murder in juvenile court, one of the things that we were able to do was I was able to get my client to have a mediation with the victim in the case, where my client was able to take responsibility and accountability for his actions and also see how his actions impacted the victim's family. For me, I think that it was important for my client to recognize that, but then it's also important for the victim to be made whole, for them to get the healing that they need as they're moving through the process too. Far too many times when we look at just the judicial system, we're just looking at the offender that's offended and not the victim that may be made harm and how that disrupted the community. And so the way that looks like, again, for me in my practice, what I've done is contacted the DA or the police officer to request the mediation once we've resolved the case. And so it's my belief that, victims of crime that participate in restorative justice like that, they have an opportunity to reduce the victim's post-traumatic stress opportunities. They can get closure on what happens to them. And then also, again, for the offender that has committed it, some of the programs that are available currently are like Music City Community Careers Program that'll teach people a vocational skill, whether that's concrete laying, pipe laying, HVAC, and they can get them equipped to be successful when they reenter our community. So I think that we need to look at both the offender and the offended and make sure that they both have the resources that they need to be able to move forward for restorative practices. Thank you.
Thank you. And Ms. Chappell.
Thank you. This is a great question. And I want to start because I'm going to take it out of order a little bit. But I think to begin, by the time a person is charged with a crime in criminal court, there is commonly been touches with the juvenile court system already. So number one, I would say buttressing and supporting our juvenile court system will go a long way toward helping the flow on into the adult system. I think the ways to do that, of course, begin with education. We are graduating 5,000 students in May in Davidson County schools, and about 3,500 of them do not read with proficiency. Those folks are going to have a hard time getting a job, and we know where it's likely that they may end up. So with regard to accountability, once you are in criminal court, you've got to have a judge that's going to be able to look at the nature of the crime, the seriousness of the offense, the level of the offense, the background of the offender, both personal and with regard to criminal justice, and weigh all of that. And we do have our most amount of discretion when it comes to sentencing and sentencing practices. And I absolutely believe that people ought to have a chance to restore themselves, either through a probationary sentence or through more programs being available when a person is in custody. What I think is most useful in the criminal court is probably going to be partnering with others in the criminal justice system to ensure that we can provide as much support as possible while still ensuring that we do have accountability for the public and we are making sure that public safety is protected. And those are really tough decisions. Thank you.
So Ms. Kimbrough, I think we'll now go to the audience questions. And
Okay.
Jane, if you can come up with 2 questions from the audience.
I can ask those for you, Joy, since I've been screening them. One of the first questions that came was, what characteristics would you consider for recommending diversion rather than incarceration?
Who does that go to first?
Okay, that question will go to Mr. Payne.
All right. What characteristics for diversion? Well, the statute already the statutes and the TBI actually have a certification for a diversion. You have to basically not have a criminal conviction or served any jail time or a felony conviction. No felony convictions and no jail time. Characteristics are, I think that anyone that's eligible, they should be considered for a diversion. I think that people make mistakes, and therefore, as far as a characteristic, just if you committed a crime, you qualify for diversion, I think that should be considered.
Okay, thank you. Mr. Shute?
Could you repeat the question so I make sure that I understand it?
What characteristics would you consider for recommending diversion rather than incarceration?
Okay, so when we're talking about, if we're talking about 4035 313 diversion, then the statute outlines the requirements, as Mr. Payne just stated, that we would have to follow in considering whether or not somebody will be eligible when they complete that form. And so based on the framing of that question, is very limited to what I would, as a judge, be able to do, because we would have to follow what the statute outlines. But obviously that's a preference to keep some type of felony offense off of somebody's record to ensure that they be able to have gainful employment and be able to get housing.
Thank you. Ms. Chappell?
Yes, thank you. So that we have 2 types of diversion, judicial and pretrial diversion. One is available through discussion between the district attorney and the defense counsel. The judicial diversion is sometimes a judge may be able to decide. Typically, those are resolved through a plea bargain agreement. If a judge is asked to make that decision, we first have to determine whether the offense is eligible, meaning is it the type of felony that is allowed by statute to be divertible? And then what qualifications does the defendant qualified as a candidate for diversion? Those are statutorily set out. Absolutely, I agree and believe that where you have a qualified defendant and a qualified offense, diversion should be allowed. I believe in people that are eligible, that have messed up once, to be able to restore their clean record if they can show they can do that. Thank you.
Thank you. And Mr. Norman?
So, yeah, I would agree with Mr. Shute. The characteristics of diversion are going to be by statute, whether or not someone has actually been arrested before, whether they've been convicted before. Now, I think what the question might be trying to ask is more of the alternative sentencing as far as the mental health court, the drug court, veterans court. And then I think we need to look towards the sentencing chapter, which deals with what is the potential or lack of potential of the rehabilitation or treatment of the defendant when determining whether an alternative sentence would be appropriate and or the length of sentence to be imposed. Now, so I think the question might have been towards alternative sentencing. And in that respect, I would follow the statutory guidelines. However, I think that we need to look towards people that are in need of treatment and actually want treatment. And there are many, many people incarcerated who want treatment. And so we need to really utilize the system that we have to get those people the help that they indeed want. But we also need to use the same guidelines to determine whether or not someone is a risk to society, to make sure that we don't have any kind of additional risk to the citizens here in Davidson County.
Thank you.
Thank you.
One more
Are we-
question from the chat.
Yes, the other question for our candidate has to do with appointing a defense attorney. The question is, after you appoint a defense attorney, would you institute a way to follow up that this defense attorney is actually meeting with the client? How would you follow up?
Okay, thank you. We'll start with Mr. Shute.
Thank you. I think that's a great question because as I was alluding to earlier about defendants having a choice in who their appointed attorney is, because of our constitutional rights, you're provided an attorney whether or not you can afford one. And so it's important that the person that is being accused of a crime has a say-so and an input with who is supposed to be representing them. Far too often, sometimes attorneys will take on appointed cases and caseloads that they can't manage, and their clients will feel like they're not being communicated with. If I'm an elected judge and I receive that type of communication from a defendant, then I would absolutely institute a way to ensure that the appointed attorneys are communicating and following up with their clients. Thank you.
Thank you, Mr. Shute. Next, Ms. Chappell.
Yes, so first I would say that Davidson County has a very well-staffed and talented public defender's office. So many people are appointed an attorney through the public defender, and that organization maintains track of its lawyers. In the event that there is a conflict with the public defender's office, a private attorney who is not employed by the government may be appointed. And in that event, I would certainly be open to having a policy to know that we've got private attorneys that are working, that are qualified, that are working hard, that are ensuring that their clients feel like they are properly protected. We have a constitutional right to counsel. I do not believe we have a necessarily right to choose our own attorney, but you do have a constitutional right to well-informed, certainly educated counsel. And I would be open to a way to follow up on that. I suppose what would happen is when counsel submits their billing requirements, those have to be approved by the trial court. So that is one way you see what the lawyer is actually doing in the case. Oftentimes now, that's not until the end of the case, but it seems like it would also be appropriate that if there were a complaint, that's something you could request from an attorney. And so I think that's one way we would make sure, because I do believe it is very important, especially for incarcerated individuals, to feel like they are receiving an excellent defense. Thank you.
Thank you. And Mr. Norman.
So this is a difficult question. There are many different aspects that would have to be considered here, because ex parte communication between a defendant and the court would not be appropriate. However, if I was to find out that an attorney was not actually contacting their client, was not actually participating with them to help prepare a defense, then I would have to take that into consideration whether or not I was going to appoint them in the future. As far as the public defender's office, they have a great staff that can actually address those issues internally. However, for the private bar, when appointing a private attorney, that is something that there should be some kind of check in place. There should. The best off the cuff answer I could say is if the information was passed to my staff that an attorney was not actually meeting and helping in the preparation and allowing the client to help in the preparation of the defense, then that is very concerning, and I would not want that person to be continued to be appointed in my court. But as far as getting the information to me, that is a difficult question purely because there is a rule against ex parte communication with the court. So I do believe that some type of system should be set up, but exactly what that system is would have to be discussed and reviewed to find a way to implement some kind of check there, which I agree with.
Thank you, Mr. Norman. Mr. Payne?
Well, in a practical sense, I used to be an assistant public defender, and we were appointed many cases, and we often had to visit our clients in jail. However, sometimes our clients who were not in jail just never came to visit with us. We might have even called them and say, hey, you need to come visit with us. They wouldn't make it to visit with us. Now, as a practical sense, in a courtroom, the judge, whenever there is a court date, I've heard asked often to a appointed person, have you met with your attorney? And the answer is revealing. Sometimes they say, yes, I've met with him. And sometimes they say no. So we have a built-in place to find that out right at every court appearance. Have you met with your attorney? And if the answer is no, why not? And then you can, from the bench, immediately say, we have I'm going to reset this case for a month, and I want you guys to meet at least 2 or 3 times before that month comes about. So you have control over that. If you want to, and I would follow up with that on a regular basis, because the worst thing you can have is a client or a person incarcerated who's been appointed an attorney, and you go a month between court dates, and that person says, I haven't met with my attorney at all. And so you could check that every time you have a court appearance. And that's what I would do. Have you met with your client?
Thank you, Mr. Payne.
Ms. Kimbrough, I think we're back to you on question number 5.
Okay. All right, question number 5 from our sponsors. In recent years, many of us have become more aware that implicit or unconscious bias can lead to discriminatory behavior, and that implicit or unconscious bias leads to discriminatory practices and outcomes in the courtroom. What do you do to defend against implicit bias creeping into your own behavior and action in the courtroom? How would you address the biases of others that you observe in the criminal courtroom? And that will go first to Ms. Chappell.
Thank you. So first, I would say there's good bias and there's bad bias. For example, my parents are teachers. I love teachers. That's a bias that I have. I may tend to listen to a teacher sometimes that I wouldn't. Obviously, people also know there is what I would call bad bias. There's bias for reasons of race, socioeconomic reasons, education, all of the reasons that we can name. I think the best way to be more aware as a judge of your own potentially implicit or unconscious bias is that you must be open. You've got to be willing to listen to the public when they come talk to you and say, hey, I don't understand why you made that decision. Tell me more about how you got there. I don't have a problem being called out for decisions that I made. And one time that, or one occasion or one years, when I served on the Board of Zoning Appeals, that's a quasi judicial board. We had to listen to litigants from both sides, present their evidence, and then the 7 of us had to deliberate publicly and make our decisions. And I think that process of doing that deliberation publicly with a group really helped me to establish for myself my own process on how I considered evidence and how I thought through the decisions that I had to make in those
20
cases.
seconds.
Those were not criminal cases, clearly, which having the constitutional implications that these do, but the process that I learned was instrumental in helping me, and I think I would bring that to the bench. Thank you.
Thank you. Mr. Norman?
And I believe that you'd have to separate yourself from bias. You have to understand and be willing to acknowledge any type of bias you have, even if it is such a simple thing as I believe teachers, or I believe teachers are good. And you have to understand when you have those biases that you have to set that aside, because you cannot have a good or bad bias and be an effective judge over people. Now, the judge, it has to look at all sorts of different situations and has to be able to listen, has to be able to show the dignity and respect to actually be able to be attentive, listen, and consider all the facts before them. And part of that, when you get into any kind of bias, especially any bias based on race, age, gender, socioeconomic status, you have to understand when it's, for an example, if you're dealing with a bond condition, like Mr. Shute was saying earlier, $1,000 bond for one person is not the same as $1,000 bond for someone else. You have to understand that the bias that you might have towards, this is a serious crime and there needs to be a substantial bond to ensure that that person comes back, is going to be very different for someone making $30,000 a year as it would be for someone making $150,000 a year. And so you have to be able to treat each person individually in your courtroom with that dignity and respect to be uniquely observant of every case. And I believe that separating your own personal biases and realizing where there is bias and stamping it out whenever possible is how you'd have to act. And in my court, anyone that I saw that has bias towards any other member of the court would be excused from the court. You cannot have any bias towards gender, race, age, anything like that, and be respectful towards other people.
Thank you, Mr. Norman. Mr. Payne?
Bias, implicit, unconscious bias. How do you address that? Well, first of all, everybody's going to have bias. As is obvious, as we're human beings, we're imperfect. So therefore, we have to, one, acknowledge that the bias exists. We have it, other people have it. But then we have to separate ourselves from that bias by basically listening to other people and understanding what they're trying to say. Understand that they have an opinion too. If everything went the way I think it should, or people, or if I only listen to the people that I think are truthful, then that doesn't make sense. I mean, we've got to be able to separate ourselves and to listen to what people are saying, apply the facts, the reality of the facts. One of the things in this country right now, it seems like we don't understand what the facts are. I think that we have to be honest with ourselves, honest with our own biases, and then deal with that on an everyday basis. If you observe bias, if you observe some type of implicit or not so much unconscious, but actions that indicate that the person is biased, you need to address it. You need to deal with that person right away. How I would address it personally, directly. I reflect every day on what I do and how I treat people. And I would act accordingly to ensure that if I am showing a bias or if there's a bias, that I am dealing with that. Because worst thing you can do as a judge is have some preference for any group or any type of information, both either good or bad. Thank you.
Thank you. And Mr. Shute.
Thank you, Joy. So for me, I have to think about the time when I was interning at the public defender's office in Nashville, and I went into a criminal courtroom and was introduced to the judge who decided to reply that I didn't realize that was your student. I thought that was your client. I thought he was a defendant. And so as one that's experienced the bias from a sitting judge in criminal court, I intimately understand what it's like to go into a place and feel like your voice isn't heard or that you're looked at differently. And so the way that I address that is to be authentically who I am in any situation that I present myself. How do I address that in my courtroom? Thinking about the Honorable Judge Ketanji Jackson Brown and watching some of her hearings and watching the numerous times that she was interrupted, those are the type of microaggressions that I think that we have to be aware of in your own self-awareness. And so when I'm talking in conversation, I have to be aware and make sure that I'm giving the space for everybody to speak and to be heard. So those are the ways that I think that I would directly address implicit bias in my courtroom. Thank you.
Thank you.
Ms. Kimbrough, it's time to go to the last question.
All right. Okay, the last question. Please close your time by explaining why we should support you rather than your opponents. What will you bring to the criminal court bench that your opponents will not? And we'll start that with Mr. Norman.
What will I bring to the bench that my opponents will not? I think this sort of goes back towards, I've grown up in a family that has touched many people's lives here in Nashville. I've grown up with so many people coming and addressing, how different things such as drug court or other situations where someone in my family has represented the person has affected their life. So it's not just my experiences over the last decade that have shaped how I see everyone who comes in front of me, but also the experiences that I've experienced before ever getting my law license, before ever determining I wanted to be an attorney. That gives me a broader view of how much a single day in court can affect someone's life. Because I think we can all agree that most people will not end up in front of a criminal court judge. Most people will never know exactly what's going on in the courtroom. I wish they did know more of what was going on in the courtroom. So the single moments that we have in these people's lives go on for the rest of their lives. So I would be and strive to be a positive influence in everyone's life who comes into my courtroom, and remember to keep myself humble and understand that I would only be serving as the judge because the people would support me to be in that position. And I would strive every day to make sure that injustice does not occur.
Thank you. Mr. Payne.
Well, first of all, let me say that about the other three candidates, they're all outstanding individuals and all outstanding lawyers. So we're all qualified. However, I think that one thing that we have to consider and why I think I should be the one you choose is because of my vast experience in very different types of environments. I grew up on a farm, spent 20 years in the Air Force. And one thing about my experience in the Air Force, you learn to understand that nothing matters but the mission. Nothing matters but what you're trying to accomplish something. Gender doesn't matter, race doesn't matter, none of that matters. What matters is, can we further the goal of what we're trying to do? And I think that I would bring that to the bench. I don't think we have any veterans on the bench at this point in time. And I have a passion for making a change in the system. I think that things I'm really passionate about is these opportunities to try to implement some restorative justice practices that are expand what we've already done. Nashville's in a great place. We've got restorative justice in our juvenile court system. We've got restorative justice programs in our system that is related to our General Sessions Court. We need more restorative justice in our criminal court system. And I believe I have a passion for that. And I believe I will bring that more so than the other candidates. We all can do practice law well. We all understand how to follow the statute. We all have good experience in using discretion. However, I believe I have the most expansive knowledge, and I would bring that. I'm a business owner. My wife and I own 3 businesses. And so therefore, I understand a lot of different aspects that I think I can bring to the bench that will benefit the community of Davidson County. So please vote for me. No pain, no gain.
All right, thank you, Mr. Payne. Next we have Mr. Shute.
Thank you for this opportunity. So for me, the thing that I think about what makes me most qualified is servant leadership. I've served Nashville as a teacher when I was teaching government and Spanish at East Lit Magnet High School. I think about the opportunities that I had working for a big box retail company at the Harding Place in the midst of the largest Kurdish community in our country. Taking time to learn their language, to communicate with them, to make sure that they are seen and that they are heard. And so when you take a snapshot of our culture, a competency that's required to be a judge, when we look at that 42% of the prison population in 2015 were Black men, and yet they only make up 18% of our state population, it's imperative that we have somebody that's on the bench that has new ideas and a fresh perspective to change the way that our criminal justice system is going. Doing something for a long time does not necessarily mean you're doing it the right way. And so we need to have somebody with the ideas that can change the way that things have been going for Nashville and our criminal justice system. So I hope that you vote for me, Marcus Shute, on May 3rd. Thank you.
Thank you, Mr. Shute. And next we have Ms. Chappell.
Thank you. And I would agree that I think we've got Davidson County has good candidates to choose from, and that's wonderful. What I believe that you should consider when I ask you to choose Chappell is that being a judge is a job, and it's an important job in our community because it allows the community to see that justice can be blind. I have the most legal experience of anyone in this race. My qualifications include not only my legal experience, but my psychology degree that has been instrumental in how I have been able to navigate the criminal justice system with everyday individuals and their families. Another thing I believe that I bring that the other candidates may lack is that I am supported strongly by lawyers that have come out publicly and vouched for my ability, not only my experience and qualifications, but my ability to be fair and impartial. Because if our community does not believe they can come into a courtroom and be treated fairly, then we are not upholding one of our greatest pillars of democracy. And the pledge I can certainly make is that every citizen, whether they are a defendant, a victim, a juror, or a litigant, a witness, is going to come into my courtroom and know that they have been heard and believe that they have been treated fairly with a respect for the process that they have been through. And I hope you'll choose Chappell on May 3rd. Thank you.
Thank you. Are we still going to do our closing statements?
We can.
I didn't know. I saw it on here. Okay, so we're going to have 1 minute closing statements. If there's something you'd like to say in closing, and that's 1 minute. And we'll start with Mr. Payne.
Thank you, Joy. Again, thanks, Noah, for putting this on. I think it's a great opportunity to talk directly to some voters. I think we got great candidates. I'd appreciate your vote. Again, I believe in compassion, restorative justice. I believe we've got to protect victims. We've got to try to make them whole, but we also got to find ways to restore people back to society once they've been held accountable. A judge's job doesn't end, it only begins at sentencing. At sentencing, it's his responsibility to ensure, or her responsibility to ensure that that person comes back to our society changed. and to prevent recidivism and whatnot. If we send people to prison, then we basically given up on them. Before we do that, we need to do everything we can to bring people back to our society while we're protecting victims and trying to keep the community safe. Vote Tillman Payne on during early voting, 13th through the 28th of April, and on May 3rd, no pain, no gain.
All right, thank you, Mr. Payne. Next, we have Mr. Shute.
Yes, Noah, thank you so much for this opportunity. Joy, thank you for moderating it. We appreciate this opportunity. And for those that got on, thank you as well. That shows how important this is to you. And again, you know, I would just leave you with that what we have an opportunity to do right now is to make a decision on where we want Nashville's criminal justice system to go. And I believe that you believe that you want to change. And for that change, you have to vote for me, Marcus Shute, for judge in Division 6 criminal court judge. Thank you.
All right, thank you, Mr. Shute. Ms. Chappell?
Yes, thank you, everyone. I appreciate all of your patience. I'll go back to my values words. I pledge to love the law, the Constitution, and my community. I will come to the bench with the peaceful knowledge that I am prepared, intelligent, and able. I will honor the Constitution and my oath of office. I will be brave to make the decisions that are unpopular. I am grateful that we live in a country with a democratic form of government, and we have interested, active organizations like NOAA in this community. And I will strive to bring justice, which means fair and impartial trials, and healing and restoration for society. Please choose Chappell. Thank you.
All right, and Mr. Norman?
You're on mute.
I am?
I mean, can you hear me now?
Norman's on mute.
Oh.
Sorry. First, I want to say thank you to Noah for hosting this, and thank you, Joy, for taking time out of your day today to be here. I want to say that I have spent the last decade of my practice actually in criminal courts, in both general sessions and criminal court here in Davidson County practicing, and that has been the focus of my career. That if elected, I will be fair, I will follow the law, and I will seek justice for all. If you want to get some more information, I would strongly appreciate it if you checked out votenorman.com, and thank you again.
All right, thank you, and thank all of the candidates. We appreciate you being here. I don't know who's going to close this out, but thank you all. Thank you so much.
I am, and thank you very much, Joy, for moderating and for the candidates for participating. I do want to thank all the attendees for your interest in being an informed voter. This forum has been recorded and it's available on Facebook on NOAA's page. So if any of your friends could not make it to this event, please have them check out the recording. Our next forum is the DA Candidate Forum, and it happens this Sunday, March 27th at 3 p.m. The primary election is on May 3rd. The general election is on August 4th. We encourage all of you to vote and to invite your friends to vote. And just a reminder that these are low turnout elections. You can have an incredible effect on the outcome. In 2018, one of these elections was won by 2,000 votes. So 1,001 votes the other direction would have led to a different result. So these elected positions are critical. The more we educate ourselves about the candidates, the better we can vote. So please plan to claim your own power by voting. And with that, I will say good night. Thank you very much.
Good night. Thanks.